New York's abortion shield, sovereign defiance, or constitutional evasion. New York's refusal to enforce a Texas judgment against Dr. Margaret Carpenter reveals a profound fracture in American federalism. The case stems from a Texas court's default ruling against Carpenter, a new Paltz physician who prescribed and mailed mifepristone to a 14-year-old patient in Texas. Texas Attorney General Ken Paxton sought enforcement in Ulster County under the full faith and credit clause, only to encounter rejection via New York's shield law. This statute protects providers mailing abortion medications to out-of-state patients, framing such acts as shielded medical care. Yet this position masks an arbitrary moral calculus, elevating one state's reproductive policy over another's sovereign rights while sidestepping fetal personhood and constitutional imperatives. It raises questions of citizen standing, where residents like those in Ulster County directly affected by local officials' decisions may challenge such actions as violations of due process under Article 1 of the New York State Constitution, asserting harm from policies that undermine interstate reciprocity and public trust in lawful governance. Moreover, the shield law's facilitation of cross-border acts illegal in Texas invites scrutiny under federal conspiracy statutes like 18 U.S.C. pair referrals, where officials' coordinated refusal to enforce judgments could constitute an agreement to commit offenses against the United States by aiding felonies across state lines via federal wires and mail. This scenario exemplifies stealthy encroachments against the principle of obster principis, resist the beginnings, where abortion advocates incrementally cross lines, extending protections from early-term procedures to partial birth abortions and even post-birth termination debates, while similarly overstepping Dobbs-mandated state jurisdictions by exporting permissive policies across borders. Such creeping redefinitions, akin to insidious communism, erode foundational truths. If life can be redefined to begin at viability rather than conception, if woman becomes fluid, and if healthcare encompasses the murder of babies, then any term becomes malleable, paving the way for government tyranny. Enforcing abortion as a right could evolve into mandating permissions for childbirth, mirroring China's former one-child policy, where reproductive healthcare justifies population controls, subordinating individual autonomy and divine order to state dictates, placing laws over God and government over humanity. The roots of this conflict trace back to the turbulent history of abortion jurisprudence in the United States, beginning with foundational privacy cases that laid the groundwork for Roe v. Wade. In Griswold, Connecticut, 1965, the Supreme Court struck down a state ban on contraceptives for married couples, recognizing a constitutional right to privacy emanating from the penumbras of the Bill of Rights. This privacy doctrine extended in Eisenstadt v. Baird, 1972, to unmarried individuals, affirming that decisions about procreation belong to the individual, not the state. These precedents set the stage for Roe v. Wade, 1973, where the court, in a 7-2 decision, held that the 14th Amendment's Due Process Clause encompasses a woman's right to terminate a pregnancy. Justice Harry Blackmun's opinion established a trimester framework. States could not regulate abortion in the first trimester, could impose health-related restrictions in the second, and could ban it in the third, after viability, except to preserve the mother's life or health. The companion case, Doe v. Bolton, 1973, broadened this by defining health expansively to include physical, emotional, psychological, and familial factors, effectively limiting post-viability bans. Subsequent decades saw the court refine and erode Roe's protections amid shifting societal and judicial landscapes. Planned Parenthood v. Casey, 1992, reaffirmed Roe's essential holding, but discarded the trimester system in favor of an undue burden standard, allowing states to regulate abortion pre-viability so long as they did not place substantial obstacles in a woman's path. This opened the door to informed consent laws, waiting periods, and parental involvement requirements. Gonzalez v. Carhart, 2007, further narrowed protections by upholding the Federal Partial Birth Abortion Ban Act, emphasizing congressional deference on medical procedures, despite dissenters' arguments that it imposed undue burdens without health exceptions. Whole Woman's Health v. Hellerstedt, 2016, provided a brief resurgence for abortion rights advocates, invalidating Texas regulations requiring abortion providers to have hospital admitting privileges and clinics to meet ambulatory surgical center standards, as these imposed undue burdens without advancing women's health. The seismic shift came with Dobbs versus Jackson Women's Health Organization, 2022, where the court, in a 6-3 ruling, explicitly overruled Roe and Casey. Justice Samuel Alito's majority opinion declared that the Constitution contains no right to abortion, returning regulatory authority to the states and their elected representatives. This devolution empowered states like Texas to enact near-total bans, including civil enforcement mechanisms allowing private citizens to sue providers, while states like New York fortified access through shield laws. Dobbs underscored the absence of a uniform federal standard, amplifying interstate conflicts as seen in the Carpenter case. To grasp the depth of this modern schism, one must delve into antiquity, where moral and legal frameworks on fetal life prefigured contemporary debates. Ancient Roman law, while permissive toward abortion in practice, reflected patriarchal priorities rather than unqualified endorsement. Under the 12 Tables, circa 450 BC, the foundational code of Roman jurisprudence, infanticide through exposure was permitted for unwanted female newborns or those deemed deformed, but abortion itself escaped explicit criminalization until later imperial edicts. Roman society viewed the fetus as pars viscerum matris, part of the mother's viscera, subordinate to paternal authority. The paterfamilias held jus vitae nexic, the power of life and death over family members, including the unborn. Thus, a husband could compel his wife to abort if he deemed the child undesirable, as evidenced in Cicero's Procluentio 66 BC, where coerced abortions underscored male dominion. Yet by the reign of Septimius Severus and Caracalla, circa AD 198-217, imperial rescripts imposed penalties for self-induced abortions, treating them as offences against marital fidelity and population concerns, punishable by exile for noble women and hard labour for others. This evolution signalled emerging recognition of fetal interests, albeit tied to state imperatives rather than inherent rights. Venturing further into biblical antiquity, the Old Testament offers scriptural precedents that illuminate fetal valuation, often invoked in pro-life jurisprudence. Exodus 21:22-25 prescribes, "If men fight and hurt a woman with child, so that she gives birth prematurely, yet no harm follows, he shall surely be punished accordingly, as the woman's husband imposes on him, and he shall pay as the judges determine. But if any harm follows, then you shall give life for life, eye for eye, tooth for tooth, hand for hand, foot for tooth, burn for burn, wound for wound, stripe for stripe." This lex talionis provision distinguishes miscarriage from maternal harm, imposing fines for the former, but equivalent retribution for the latter, implying the fetus holds value, but not full personhood equivalence. Interpretations vary. Some scholars, as in traditional rabbinic exegesis, see no harm as referring solely to the mother, with fetal loss meriting compensation. Others, aligning with pro-life views, argue it protects both, as harm encompasses the child. Numbers 5:11-31 details the ordeal of bitter water for a wife suspected of adultery. "If no other man has lain with you, be free from this bitter water that brings a curse. But if you have gone astray, then the Lord make you a curse, and may your thigh rot and your belly swell." Some exegetes interpret this as inducing miscarriage if guilty, yet the text emphasizes divine judgment on infidelity, not endorsement of abortion. Genesis 2:7 states, "And the Lord God formed man of the dust of the ground, and breathed into his nostrils the breath of life, and man became a living being." Often cited deposit life begins at first breath, though pro-life readings extend this to conception via Psalm 139:13-16. "For you formed my inward parts, you covered me in my mother's womb. Your eyes saw my substance, being yet unformed." Deuteronomy 30:19 enjoins, "I call heaven and earth as witnesses today against you, that I have set before you life and death, blessing and cursing. Therefore choose life, that both you and your descendants may live," framing life-affirming duty as covenantal duty. These ancient sources underscore a continuum. Roman law prioritized paternal and imperial interests, while Old Testament texts embed fetal protection within divine moral order, rejecting arbitrary termination. Modern deviations, as in New York's shield law, echo Roman permissiveness, but divorce it from any countervailing ethic, clashing with constitutional roots in natural law. Consider the core inconsistency, amplified by this history. Texas law recognizes fetal rights at the heartbeat stage, criminalizing the provision of abortion-inducing drugs as unlawful medical practice. New York, conversely, extends no such recognition until birth, treating the fetus as mere potential life. When Carpenter's prescription crossed state lines via federal mail, Texas asserted jurisdiction over the harm inflicted within its borders, a hospitalized minor, and an extinguished fetal existence. New York's shield law intervenes not by disputing facts, but by declaring the act immune from enforcement, invoking public policy to nullify a sister state's judgment. This maneuver echoes the critique in Taylor v. Porter, 4 Hill 140, NY 1843, where the court invalidated statutes enabling wrongs under guise of process. As Justice Nelson articulated, permitting the legislature to authorize deprivations renders constitutional protections nugatory, transforming safeguards into hollow verbiage. Article 1 of the New York State Constitution demands due process, prohibiting deprivations of life, liberty, or property without it. If the fetus constitutes life, a premise Texas law affirms, and federal statutes like the Unborn Victims of Violence Act tacitly endorse, New York's reviewed works are wrong. The shield law does not merely protect local providers, it facilitates extraterritorial acts that undermine Texas sovereignty. States retain police powers over health and morals, as affirmed in Dobbs, which returned abortion regulation to democratic processes. New York's intervention thus inverts federalism, allowing one state to export its permissive regime into another's prohibitive one, akin to mailing prohibited substances across borders without consequence. Analogies abound, yet reveal selective application. Federal law bars interstate shipment of controlled substances like psilocybin or cannabis, respecting state bans despite varying legalities. Gun dealers in Texas cannot mail firearms directly to New York residents, bound by federal regulations requiring licensed intermediaries and local compliance. Why then does mifepristone evade similar scrutiny? Proponents cite a waiver of approval and non-controlled status, but this semantic distinction crumbles under examination. Prescription requirements necessarily controls their force and legally, transforming a mere pill into regulated medical intervention. Carpenter's telehealth consultation, conducted over federal wires, constituted practice in Texas by effect, soliciting and enabling an act to lead there. New York's protection ignores this, prioritizing reproductive health, euphemism for terminating fetal life, over consistent interstate norms. This hypocrisy extends to other life-ending practices. If New York shielded providers mailing euthanasia drugs to states where assisted suicide is banned, framing it as end-of-life healthcare, the outcry would be immediate, exposing the shield law's selective mercy as arbitrary favoritism. Similarly, sales tax comparisons highlight the inconsistency. New York aggressively pursues out-of-state companies for failing to collect and remit taxes on shipments into the state, asserting jurisdiction over interstate commerce regardless of the seller's location. Yet, when Texas seeks to enforce its laws on pills shipped into its borders, New York refuses cooperation, treating abortion aids as exempt from the reciprocity applied to fiscal obligations. If a vendor dodged sales tax by claiming a self-declared exemption, courts would reject it outright. The shield law operates as such a dodge, prioritizing ideology over uniform enforcement. The minor's plight intensifies the injustice. At 14, she navigated parental pressure and state mandates, yet New York's law enabled a remote physician to intervene without in-person evaluation, risking complications that led to hospitalization. This scenario underscores the shield law's capriciousness. It carves exceptions for abortion, while enforcing reciprocity in mundane matters like traffic fines or commercial judgments under the Uniform Commercial Code. Full faith and credit, per Article 4 of the U.S. Constitution, demands respect for sister states' acts unless repugnant to fundamental policy. Here, New York deems Texas's fetal protections repugnant, yet its own adoption laws mandate the child's best interest post-birth, a glaring hypocrisy. The coordinated actions of officials like Attorney General Letitia James and Ulster County Clerk Taylor Bruck in defending and applying the shield law could cross into federal conspiracy territory, where their knowing facilitation of acts deemed felonies in Texas via interference means might violate 18 U.S.C. Paraphorals 3.7 and 3 by conspiring to commit offenses against the United States, regardless of state-declared immunities. New York's adoption framework, governed by Domestic Relations Law, Section 114, explicitly requires judges to determine that an adoption promotes the best interests of the adoptive child before granting an order. This standard prioritizes the child's health, safety, emotional well-being, and stability, often involving home studies, background checks, and assessments of prospective parents' fitness. The Adoption and Safe Families Act, ASFA, incorporated into New York law, mandates termination of parental rights proceedings if a child has been in foster care for 15 of the most recent 22 months, unless exceptions apply, to expedite permanency in the child's best interest. Courts weigh factors like the child's age, sibling relationships, and cultural needs, ensuring placements serve long-term welfare over parental convenience. Yet this rigorous post-birth protection contrasts sharply with pre-birth indifference. If breath marks the threshold for best interest safeguards, why withhold them from viable fetuses? Such policies expose a moral schism, where the state champions the born child's interests through exhaustive scrutiny, but permits termination of the unpromul without analogous consideration. Ultimately, this dispute transcends borders, probing the origins of rights. The Fifth Amendment secures life, liberty, and property, rooted in natural law principles the founders deemed creator-endowed. Fetuses, absent intervention, mature into citizens with voting rights and full autonomy. Denying them protection based on location or maternal choice erodes this foundation. New York's stance does not shield liberty, it licenses evasion, permitting strangers to dictate life in distant states. Federalism thrives on mutual respect, not selective nullification, until courts compel uniformity, perhaps via supremacy clause challenges or congressional action. This patchwork invites chaos, where zip codes determine destiny and constitutional ideals yield to ideological whims. The Ulster County clerk's dismissal may stand today, but it invites higher scrutiny from citizens with standing to sue. As residents of their jurisdiction, Ulster County taxpayers and voters possess a direct interest in ensuring officials uphold due process and avoid facilitating wrongs, potentially through mandamus actions or Parrott 1983 claims alleging deprivation of rights. Taylor Progretti reminds us, statutes cannot legitimize wrongs without eviscerating the Constitution. New York must reckon with this, lest its shield become a sword against the unborn and the Union itself. And now the poem. In New York, a shield law stands tall, defying Texas, ignoring the call. Pills cross borders, a minor imparent tentress claim and the enchantress lady summer so. From Rose Fall to Dobbs' decree, states war on no unity. Conspiracy whispers, standing to sue. Stealthy encroachments, tyranny true. Redefine health, murder care. From womb to birth, a slippery snare. Obsta principiate to resist the distort, lest God's law yields to state's dark art. To remit state, dark art. Page 50.